Most of you are here today because you're thinking about committing your resources to access the Canadian markets and you want a sense of what you're getting yourself into. Depending on the nature of your business, not all of what we covered today will apply to you. But if we are successful, at the conclusion of this hour, your thinking about your next steps will be a little more advanced, and you should have a pretty good sense of the areas into which you will want to explore more deeply before you make decisions. My comments are going to focus on the Canadian legal environment, and in particular on the 5 topics you see on the screen. Let me start by saying that Canada is a federation comprised of 10 provinces and 3 territories. Legal authority is divided between the federal and provincial governments, although there is some overlap. The Canadian legal system is based on English common law, with the exception of the province of Quebec, which has a civil law system based on the Napoleonic Code. Canada also has a significant body of law relating to the rights of Aboriginal peoples. This includes the government's duty to consult with and, if required, to accommodate the interests of Aboriginal peoples, primarily concerning land or resource development in areas where Aboriginal peoples have a legal or traditional interest. This obligation may extend to developers of projects on or affecting these lands. There are 2 overarching pieces of legislation I want to comment on, dealing with foreign investment and competition. And this is federal legislation, so it applies across Canada. There's a Canadian business story that's been in the international news the last couple of months. I was in China last month and it received fairly extensive coverage there. In August of this year, BHP Billiton sent a bit of a shockwave through the Canadian public markets by making an unsolicited $40 billion hostile takeover bid for the shares of Potash Corporation of Saskatchewan. Much has been written in the Canadian media since the offer was tabled, focusing on whether the proposed takeover will provide a net benefit to Canada. The reason for this debate is that foreign investment in Canada is subject to the notification and review requirements contained in the Investment Canada Act. The system is set up to review investments made by foreigners to ensure that there is a net benefit to Canada resulting from the investment, particularly in the areas of economic and employment growth. There are 2 distinct steps to the process outlined in the Investment Canada Act: notification and review, and not all transactions are reviewable. The Act requires all foreign investors to file a notification with Industry Canada whenever the investor plans to start up a business or to acquire control of a business in Canada. The Act defines the acquisition of 1/3 or more of the voting shares of a corporation as an acquisition of control. And in the case of unincorporated businesses, control is defined as being majority control. Generally speaking, a transaction will only be reviewed in 3 circumstances. First, if the investment exceeds certain financial thresholds tied to the value of the Canadian assets being acquired. Secondly, if the investment could affect the national security of Canada, regardless of the amount of the investment. And thirdly, if the investment relates to Canada's cultural heritage or national identity. Particular industry sectors, such as telecommunications, financial services, broadcasting, and publishing, are subject to additional federal regulation, some of which deals with foreign investment. Canada has no exchange control or currency regulation. Let me turn now to competition regulation. Even if the BHP Potash case were determined by the government to provide a net benefit to Canada, the investment still may be subject to a merger review under the Federal Competition Act. Under that act, there is a formal system of pre-merger notification, which may in turn trigger a merger review. The test on a merger review is whether the merger or proposed merger prevents or lessens, or is likely to prevent or lessen, competition substantially in a relevant market. The Competition Act also prohibits non-competitive behaviors, such as, among other things, conspiracies, arrangements or agreements to fix prices, allocate markets, or lessen the competition, bid rigging, false or misleading misrepresentations, or pyramid selling or multi-level marketing. The Act provides that anyone who suffers loss or damage resulting from non-competitive practices has the right to sue for damages. For the majority of foreign businesses entering the Canadian marketplace, their investment will not be subject to review under either the Investment Canada Act or the Competition Act, and more typical business considerations will apply. There are a number of structural options available to you when considering doing business in Canada. You could incorporate a Canadian subsidiary corporation, establish a Canadian partnership or limited partnership, enter into a joint venture or similar type of arrangement with an existing Canadian business, or enter into some type of marketing arrangement with an existing Canadian business, such as an agency agreement, a distribution agreement, or a Canadian franchise. And I'll touch briefly on these vehicles in a moment. One of the quickest entrees into the Canadian market would be to acquire an existing Canadian operation by way of asset purchase, share purchase, or amalgamation. Structuring an acquisition sometimes can get quite complex, as it requires a fairly detailed tax analysis both for the seller and the buyer, but there are other considerations as well. Generally speaking, U.S. buyers almost never want to buy assets, as the Canadian operation then would be considered a branch operation with adverse tax consequences. Whether you acquire an existing business or set up your own operation in Canada, you likely will want to use a Canadian subsidiary corporation. A corporation in Canada can be incorporated federally or provincially for a nominal fee. There are no corporate law restrictions preventing foreign persons from being shareholders of a Canadian corporation. Shareholders are not liable for the subsidiary corporation's obligations, except to the extent of any shareholder guarantees. To incorporate a Canadian company, the business name must first be reserved. This is not expensive, but it can take time and may become an issue if you want to carry on business in Canada under your primary business name and that name has not previously been protected in Canada. A corporation in Canada is managed by its board of directors appointed by the shareholders. There are certain residency requirements for directors of Canadian corporations. Under federal and some provincial legislation, 25% of the directors must be Canadian residents. If there are 3 directors or less, one of them must be a Canadian resident. Directors cannot transact business at a meeting of directors unless at least 25% of the directors present are Canadian residents, although there is an exception to this requirement in certain circumstances. A corporation that has publicly offered securities currently outstanding to more than one shareholder must have at least 3 directors, 2 of whom cannot be employees or officers of the corporation. A person is disqualified from becoming a director in Canada if he or she is under the age of 18, is not an individual, or is currently bankrupt. Except in limited circumstances, shareholders, directors, and officers are sheltered from liabilities of the corporation, including their own negligence when acting in their appointed role within the corporation. Generally speaking, payments to foreign owners from Canadian corporations are subject to a 25% withholding tax. This rate can be reduced or eliminated, however, through the application of tax treaties between the 2 countries, or pursuant to certain exceptions available under the Income Tax Act. The second most popular form of doing business in Canada is the limited partnership structure. In a limited partnership, a limited partner is only liable for the debts and obligations of the partnership to the extent of his or its investment in the partnership, whereas the general partner is liable for all of the debts and obligations of the partnership. There also can be tax advantages for limited partners, as profits and losses can be distributed to limited partners in proportions contractually agreed to, and which need not be proportionate to the amount of capital invested by them. Losses distributed to limited partners can be used to offset other income earned in Canada. Limited partnerships in Manitoba are somewhat unique in a way that is beneficial to limited partners. Generally in Canada, limited partners will have liability as a general partner when they take part in the management of the business. In Manitoba, the legislation provides that where a limited partner takes part in the management of the business, the limited partner will only be liable for the debts of the partnership to the extent that the creditor did not know that he was dealing with a limited partner at the time the debt was incurred. Because of this favorable legislative treatment, Manitoba is considered a desirable jurisdiction for establishing limited partnerships. Turning now to marketing arrangements, agency agreements are not specifically regulated in Canada, nor are distribution agreements. Canada does not have federal franchise legislation. However, a number of provinces do have franchise legislation, and the content varies from province to province. Lastly, let me touch very briefly on intellectual property law in Canada. For countries that have regulated in the area of intellectual property, the scheme of the legislation tends to be very similar, so I won't spend too much time on it here. In Canada, intellectual property is primarily regulated by federal regulation. Patents are protected by registering them federally. To be registered, patents must be novel, possess utility, and not be obvious. A patent registration in Canada is valid for 20 years. Trademark rights arise as soon as the mark is used in association with the wares or services, but without registration, that right is limited to the geographic area of use. For broad protection, you must register your trademark under the Federal Trademark Act. There also is federal legislation providing for protection of registered designs, although you lose the right to register the design if it has been used for more than 1 year before your filing date. Copyright in Canada automatically subsists on the creation of an original work, whether or not it has been published, if at the time the work was created, the author was either a Canadian citizen, a British subject, or a citizen of a country that is a member of an international agreement for the protection of copyright to which Canada is a party. This concludes my part of the presentation. Thank you, and again, I hope you enjoy your time in Winnipeg.